afternoon to everyone, and welcome to our first of a series of events this fall being sponsored by the Center for Human Rights and International Justice. Before we get started, I'd like to ask everyone to put themselves on mute. I'm Brinton Likes, and I'm a professor of community and cultural psychology here at Boston College and co-director of the Center for Human Rights and International Justice. It's a pleasure to welcome you today. My own work is in feminist activist scholarship and focuses on rethreading life in the wake of gendered and racialized violence, as well as migration and post-deportation human rights violations and resistance. I will briefly introduce my colleagues, both of whom are affiliated with the Center for Human Rights and also members of the Boston College community more broadly. After each speaks, we will then respond to as many of your questions as we can accommodate in the time that we have today. To facilitate that process, I'd like to invite you to send your questions to the speakers through the Zoom question and answer function. If you have a particular speaker in mind, so indicate as you submit, and I will select questions and direct them to each of our presenters. María Emilia Bianco has an MSW and a Master's in Communication, and also received her PhD from the School of Social Work here at Boston College. She was awarded the Kelsey A. Renenbaum Memorial Fellowship to support the work about which you will hear today from the Center for Human Rights and International Justice. In recent years, Amelia has engaged in participatory and action research projects with immigrant communities in the greater Boston area, and worked with community organizations to develop a grassroots humanitarian initiative to support asylum-seeking mothers who resettled in this area. Prior to that, she worked in international development programs with women in Latin America for the nonprofit organization Techo para mi país, and then with Oxfam. Emilia is currently working in a part-time capacity at Boston College and also at Loyola University. She will discuss her recent research with 17 Central American mothers who crossed the US-Mexico border with their children and resettled in the greater Boston area, beginning in about 2014. She describes what these mothers endured in their countries of origin and some of the push factors that led them to their journey north, analyzing those experiences during that journey as well as the challenges they face in the US territory. Her study observes how multiple forms of violence, precariousness, and institutional neglect transcend international borders and expose mothers and their children to what some scholars have called unending suffering. She will conclude with some recommendations for rethreading and reconstructing international human rights frameworks. Dan Kanstroom is professor of law and the Thomas F. Carney Distinguished Scholar at Boston College's Law School. He's also the faculty director of the Rappaport Center for Law and Public Policy and the co-director of our Center for Human Rights and International Justice. He has published widely in the fields of US immigration law, human rights, criminal law, and European citizenship and asylum law. His recent work includes Aftermath, the deportation law in the New American Diaspora, and Deportation Nation, Outsiders in American History. Dan will briefly analyze and critique a recent Supreme Court decision in DHS versus Thruasigian. The court majority ruled that an asylum seeker who was arrested and placed in fast-track deportation system known as expedited removal had no constitutional right to petition for a writ of habeas corpus when the asylum claim was summarily denied. This meant that no federal judge would hear the case, only government employees. That ruling will facilitate expedited removal and deportation proceedings near the US border and more generally in the US. So we'll begin with Amelia, who will present for about 20 minutes, and then Dan for about 15, and then we'll be delighted to address your questions and enter into as much discussion as we can.
Brinton, before Amelia starts, let me just tell everybody we are recording this session. And so people need to know, so if you don't want to be recorded or part of a recording, you should know that now before we start. Sorry to interrupt, I just want to make sure we got that in there.
Thank you, Anne.
Okay, so thank you, Brinton, for that presentation. I will start sharing my screen. Okay, so hello everyone. Thank you so much to BC Center for Human Rights and International Justice for inviting me to present today and for all the support that you have given me for this research. Thank you everyone who made time to came today. As Brinton said, I will be sharing some of the findings of my dissertation research, which was a qualitative study based on interviews with 17 asylum-seeking mothers from Central America who crossed the US-Mexico borders carrying some of their children with them. So I would like to give a little background on the migratory crisis. Since 2015, there has been a rising number of women and children crossing international borders worldwide. In Central America, conditions of poverty, violence, and inadequate institutional protections of human rights, which affected women and children, have pushed mothers to cross the borders to the United States with their children, seeking safety and better livelihoods. We know that migrants from Central America, including women and children, can experience multiple human rights abuses before, during, and even after migration, producing, in cases, experiences of unending suffering, which can lead to possibly negative mental health outcomes for some of them. Despite running away from violence and despite their multiple humanitarian needs, the US is scaling back on the protections for asylum seekers. As you know, the US has historically been the global leader in resettling refugees and asylum seekers who are defined as people forced to flee their home countries to escape war, persecution, or violence. However, the Trump administration had enacted several restrictions that now will make it very difficult for asylum seekers to obtain humanitarian protections in this country. Professor Kanstroom will discuss this topic in more detail. I will just mention briefly the recent Supreme Court decision that Brinton was talking about, the new rules related to work authorizations, which will make more difficult for asylum seekers to work in the United States for those who are already living here. These policies add to the previous Remain in Mexico policy, the policies of family separation at the borders, the push to not recognize domestic violence and gang violence as causes for asylum, and the multiple denounces of mistreatment and discrimination in immigration detention centers. So now I will present on my study with the intention of bringing the voices and the personal stories of asylum seekers. My study is theoretically grounded in human rights frameworks and also in feminist theories, and it observes the complexities of mothering while migrating and seeking asylum. In particular, it documents the stories of mothers who migrated with their children from 2014 to 2018, have resettled in Boston while they wait for the adjudication of their asylum claims. So through analyzing participants' narratives, I explore first the challenging context in which these women have lived and mothered their children. Second, their maternal practices to survive and support their children in this context. And third, the impact of both context and difficult maternal practices on maternal well-being. So as I said before, the study is grounded on a human rights-based approach. This approach allows me to observe that the multiple experiences and needs of these women and children relate to direct violations of basic human rights and international human rights. What most guided my thinking was a statement from scholar Ive about human rights covenants as discourses that can be challenged and reconstructed, and about our responsibility as scholars and practitioners to do so. So ultimately, my study aimed to challenge current discourses to include specific protections for women who cross international borders with their children. The study is also grounded in feminist thinking. I will explain briefly some of the main concepts that I used throughout my study. So motherhood and mothering have been subjects of feminist thinking throughout the last century. However, previous scholarship has focused on the experiences and concerns of white middle-class women and has sometimes failed to include those women who mother from the margins of societies, including immigrant mothers. Because of this, Patricia Collins have called to shift the center in maternal thinking to focus on those who mother from the margins. With respect to marginalized mothers, anthropologist Shepard Hughes has observed that marginalized mothers throughout the world have to give birth and raise children in conditions that are hostile to child survival and to their own well-being, and that these conditions are defined by unequal power relationships and severe social and institutional neglect. Another scholar, Sarah Ruddick, has theorized that maternal practices relate to the demands of preservation, growth, and social acceptability of children. And with these regards, Collins has highlighted that that for women in marginalized positions, their main maternal practice is much related to the demand of preserving the lives of their children in harsh environments, which are permeated by violence, poverty, and pollution. She has stated that in contrast, white middle-class mothers in the US can focus more on the emotional well-being of their children and their own, because physical survival is assumed for children who are white and middle-class. While feminist theories acknowledge contextual conditions oppressing the lives of women, they also emphasize women's agencies to adjust and resist these conditions. Once again, according to Collins, resistance for marginalized mothers could mean enduring hardships of oppressive conditions themselves, but creating stability and spaces where their children can conceive a different future. So as you will see, this is what immigrant mothers in this study did by leaving their countries, enduring the multiple hardships of the migratory journey to bring their children to what they consider to be safer spaces. Before starting the study, I was involved with several community organizations, some of whom are present today, in an initiative to provide humanitarian support to asylum-seeking mothers. Once I started the study, I had the collaboration of De Novo in all stages of the project. In terms of recruitment, most of the mothers who participated were referred by De Novo immigration attorneys. I interviewed all the mothers using a semi-structured questionnaire, which included open-ended questions and also creative activities and a photo elicitation to elicit mother stories. The questionnaire also included mental health scales to measure anxiety, depression, and PTSD. I will go fast, so if there are questions, we can come back to these sections. So the data was mostly composed of women narratives, which I analyzed using narrative thematic analysis methods. To protect participants, I de-identified the data for analysis, and today I will be presenting women's words under pseudonyms. Also, to clarify, the pictures that I am using do not represent the women in the study. So the final sample consisted of 17 adult women, the majority of whom were from El Salvador. 70% of them were single mothers at the time of crossing the border. They had between 1 and 4 children. All of them crossed with at least one of those children. All of them were detained at detention centers at the borders, and they passed a credible fear interview. And all of them had seen an immigration attorney upon arrival to Boston at least once, and 6 had secured legal representation throughout their cases. So now I would like to bring the voices of women participants to our discussion. I will read pieces of Elenas Story because this story is very illustrative of how mothering in this context looks like. Elena was 21 at the time of the interview. She was a widow and she had 2 teenage daughters. These are her words. What led me to the decision to cross the border was that I started a business and they started extorting me. Extortions became stronger. They said that they knew where my daughters were, where they studied. They sent me pictures of each of them. They described me how they will kill each of them. They said that if I didn't pay them, they will murder me as they murdered my husband. One day, early at dawn, I took my mother and my older daughter and I left them in a place with another family. I only took one of my daughters with me, and we adventured to cross the borders. I asked her, "What did your mother say?" She answered, "She was sad, but she said our lives were in danger. They had killed my husband, then they murdered my brother. She said to me, 'They are not playing. I prefer to have you far away than having to bury you.' Because there," she explained to me, "you make denounces. They ask you for evidence, but nothing happens. They don't make justice." I asked her again, "Why did you bring this girl and left the other one?" She said, "Because this girl was younger. She was also the one who was receiving the most threats. Elena cries. It was a very difficult decision because I couldn't bring the two of them. I asked her, what did your daughter say about this decision to flee? She said, the girls didn't know we were coming to the US. I never told any of them because I didn't want to hurt their hearts. I didn't want to hurt the heart of any of them, Elena cries. So that is how I brought her. I told her we were going for a leisure trip, a pasear. When we entered the bus, she asked me where we were going, and I said, we are going to the United States. Elena starts crying loudly. She asked me, why do I have to live like this at dawn, at night, and leave my sister? And she started crying that she didn't want to leave, and I asked her to support me, to be strong so we can come. I brought her with lies because I couldn't find the way to tell her, to leave the comfort of our house to come here. And now I see her and I tell to myself, did I do right? Then Elena goes on to tell me her story in detention. When we arrived to the Perrera, the dog kennels, and we were separated, I was all wet because we were crossing the river. I was always protecting her, and I fell there on the mud. When we arrived at the Perrera, my daughter was received perfectly. I was mistreated. They offended, they shouted, they make fun of oneself. They take our children away. When they took my daughter, I started crying because it was something new for me. Where are they going to take her? Are they going to take her away from me? They put them in a different place, nearby, all by themselves. They bath them, they give them pants. For us, they leave us all wet. So we looked behind the bars with my daughter. We both cried to see how far we were from each other. Elena explains to me, in theory, we hurt our children bringing them as we bring them, suffering from hunger, from everything that happens. When I saw my daughter behind bars in detention, I said to myself again, what have I done? So there were very similar stories, but there were also many nuances in the stories. However, all mothers in the study have resisted conditions of violence, precariousness, and institutional neglect. And even though these conditions manifested differently, they continued affecting mothers and children across borders, as this table shows here. Some highlights I would like to make now is first that mothers experience the threat of or the fear of having their children taken away from them or hurt across borders. In the countries of origin by gangs or intimate partners, in the road by criminal groups or individuals, and in the US by the policies of family separation in detention. Second, poverty was inflicted in the countries of origin by criminal groups that force mothers to close their businesses or took control of their houses or assets. Also by the high fees some women had to pay to those who guide them across borders. And in the US, by asylum policies that restrict the access of asylum seekers to work permits. As scholar Chandra states, enforced poverty is a feature of asylum policies in many host nations. And this will become worse now with the recent changes in the restrictions to acquire work permits. Third, I want to emphasize that human rights frameworks establish governments as duty bearers in the protection, fulfillment, and respect of human rights. However, the findings from this study show that mothers have not received adequate protections in any of the countries that they have lived, transited, or sought asylum. As such, I write in my dissertation that in practical terms, this is a stateless population, as none of these national states take serious responsibility in protecting their rights. Scholar Ramji Nogales has pointed out to the inadequate international human rights frameworks that protect asylum seekers in transit. And in US territory, refugee protections exist, but this study found that these were not easily accessible for mothers who could not afford an immigration attorney. So as a consequence of the lack of institutional protections, the lack of fathers for some of these children to protect them, mothers were the only ones responsible of guaranteeing the right to life of their children by relying on extreme sacrifices and resisting extremely difficult circumstances. So mothers in this study were involved in difficult maternal practices as a result of this context. I will only focus on some of them for this presentation. So similar to other marginalized mothers, for these mothers, most practices were focused on the preservation of the lives and integrity of their children. In fact, mothers became mobile because of this. 88% of the mothers in the study said that they migrated to protect their children from some form of violence. However, given the inaccessibility of these women to find safer ways to seek international protections, in order to protect their children from danger, they have to expose themselves and their children to the dangers of the journey. As we saw from Elena's testimony, some mothers in this study separated from some of their children, leaving some behind while bringing others with them. As Shepherd Hughes studied how mothers triaged what children to feed and which ones to let die in conditions of extreme poverty in Brazilian shanty towns, immigrant mothers in this study also triaged or made selective decisions of which children to bring and which ones to leave according to survival goals in conditions of extreme violence. These decisions were not easy for any of them. Mothers also relied on extreme sacrifices such as going without food and water to give this to their children in the journey, in detention and beyond. And however, sacrificing to see their children happy sometimes gave meaning to mothers' own suffering. I will read the words of Lydia here. There was a moment in which I wished I died here in the United States. It was when they left me out in the streets. I slept one night on the street with my children, Lydia cries. I was able to find food for my children. Even if I do not eat, I came chubbier than I am now, she explained to me. But I tell them, it doesn't matter how I am, as long as you have what you need and you live happy here, she cries. You have to study, because they gave them the opportunity of studying, she explained to me. I never asked for food while in Guatemala. Why here? But one has to fight and move forward. If my children are fine and nobody hurts them, I'm happy. That is more than enough. If they are fine and happy, I am happy. I see them happy and I will fight for them, Lydia cries. From this testimony, we can also see how mothers fight or resist in the sense that Patricia Collins had written by enduring hardship in order to create a better place and future for their children. Mothers resisted what Lydia defined as a bad future for her and her children. So by listening to these stories, I felt that the internalization of this maternal role of preserving the life of their children gave these mothers some feeling of legitimacy to contest local conditions and also national borders to provide what they believe were healthier spaces to raise their children. Women participants, as you saw, experienced many suffering-inducing events across borders. Maybe as a result of this, most of them express symptoms of anxiety and depression. I could provide more details on mental health for those who are interested. But what I want to emphasize here are three things. First, that post-migration stressors contributed to these negative feelings. This included the anxiety over the possibility of being deported, of not being able to work or to secure an immigration attorney. All these stressors are related to the way asylum policies are implemented. Second, that several of the maternal practices mothers engage with to protect their children cause deep emotional pain in mothers. Several question or blame themselves for the suffering this produced in children instead of blaming the difficulties, or they also blame the difficulties but also themselves. And third, the narratives also talk about positive feelings, resiliency, strength, and growth. Growth was related to both the practices of migrating and mothering. For example, Alba from Guatemala said, imagine leaving the country by myself with my child. That takes a lot of courage. I realized that I am braver than what I thought I was. So these stories of growth spoke to me about an empowering potential of mothering and migration. So briefly, the first recommendation I would do based on these findings is to support existing asylum protection and stop dismantling what we have, that even though they are not perfect, they could provide some protections to mothers and children running away from violence. The second recommendation would be to challenge and reconstruct these existing international human rights frameworks to include more provisions for the protections of the right to mothering in migration. This could include the right to be with their children at all times and the right to raise them in transborder conditions that are not hostile to the survival and well-being of both mothers and children. And third, to include asylum-seeking mothers as protagonists in these processes. As observed in this study, asylum-seeking mothers have voice, have agency, have strength, and particular perspectives that need to be included in the reconstructions of these frameworks. So thank you so much, and thank you all the organizations and people that helped me throughout this project.
Thank you so much, Amelia. And we will look forward to discussing this more with you after we hear from Dan Kanstroom.
Okay.
Thank you. That was a very moving and very important presentation. I'm going to speak quite briefly so that we have the maximum amount of time available to do questions. But I did want to highlight something which I have termed, for the purposes of this PowerPoint, and I take this from an article that I published about 1.5 years ago, a testing crucible of basic principle. That phrase comes from a law review article that was written in the early 1950s about habeas corpus and immigration enforcement and the role of judges. And what I want to talk about in light of the case that was just decided by the Supreme Court is that we may be entering a historical period that is unlike anything we have experienced for more than 100 years, in which judges and constitutional protections may become unavailable to people, even people who are seeking asylum, and certainly to non-citizens more generally. So this is compelling in a technical legal sense, but it is also a serious problem in terms of human rights protections. Now I'm trying to just, I refer to this as a tectonic moment. And by that I mean that what we're witnessing is a clash of underlying forces. The basic power of the government to enforce border controls and to mandate a deportation system has really almost never been stronger than it is in this country. And in the hands of this administration, it's become extremely large and dangerous. Of course, this is not new, but it has gotten much worse. And what we face now is also the question, the eternal question of in enforcement systems, who guards the guardians? That is to say, these people, if you look on the lower left slide there, of Customs and Border Protection agents, who are different from ICE, but they work together. ICE is mostly the internal enforcement agency, but CBP, so-called, also does internal enforcement now, are operating with very little in the way of restraint. And the question is, what is the future of due process for non-citizens? Is there a future for due process? And what happens if there's no judicial review, especially habeas corpus? So a lot of what I want to talk about, and what this case is about, is habeas corpus, which is an ancient mechanism for saying the executive or the sovereign or the king or the government cannot operate in a completely unconstrained way. Habeas corpus in Latin means to have the body, to bring the body of the person who is detained, arrested, or held by government agents before a judge in a setting in which law can be applied to what is happening to that person. So that's what is at stake. Is there law in immigration enforcement or not? Is there due process in immigration enforcement or not? That's where we are right now, down to these really basic tectonic questions. The last time this was confronted in this way was a long time ago. The foundational case is called Yamataya versus Fisher, and you have to go back to 1903. This involved a woman who had entered the United States, and basically the position was taken that she had no right to any due process. And the way her lawyers put it, is worth rereading. They say our records will be searched in vain for authority sustaining such a proceeding. You'd have to go back to before Magna Carta, that's 1,000 years ago or more. Question was, will the highest court of the land hold the proceeding to be due process of law? That was a proceeding which she basically had no rights. In fact, the proceeding was held in English, a language she did not speak, just for example. She had no lawyer, nothing like that. They said to do so would be to strike a blow at the very foundation of free government. Well, the court did say that she would have some due process protections. The protections she was given were rather minimal. In fact, they said if the proceedings were conducted in a language she didn't speak, that was her misfortune. But those protections of due process have evolved over time. So the foundational principle since 1903 has been there is due process for people who have entered the United States, even if they've entered without authority, even if they've entered without permission, even if they've been here a short period of time. This issue came up again in the 1950s. This is when Henry Hart wrote the article from which I took the crucible line. He said that courts have a responsibility, that is to say the legal system, judges, to see that statutory authority was not transgressed, that reasonable procedures are being used, and that there is not an uncontrolled official discretion. Meaning that if an agent doesn't like the way a person looks or doesn't believe them, can they just deport them with no further process? That's an incredibly high amount of discretion, which we would not tolerate in almost any other area of law. But in Trump time, we're seeing an expansion of these kinds of systems, and that's what's led to this case. Expedited removal actually goes back to 1996, and it was put into place by Bill Clinton. It allowed government agents to exclude, and it primarily for many years applied only at the border, looking for what they called frivolous asylum cases. Even there, it was highly criticized as dangerous because it gave so much power to government agents. But this got worse in the Bush administration, the George W. Bush administration, when it was expanded to include many people within 100 miles of a land border who could not demonstrate that they had been here for more than 14 days to the satisfaction of an immigration officer. And once that expansion started, we started seeing a lot of problems and a lot of mistakes were made, including US citizens being deported erroneously. This is part of the reason we started our post-deportation human rights project here at the Center for Human Rights and International Justice. Now, asylum seekers were granted some special procedural protections. They get basically a second bite at the apple. I'll talk about that in a minute. But the most important point is that Trump and the administration are seeking to expand this to apply to people who have been here for up to 2 years anywhere in the United States. That's a big part of what is at issue in this litigation and in some others. What the law does is it says if a person is caught in the United States and they haven't been here, they can't prove to the satisfaction of that agent, and again, remember, there may be no judge in this business at all, that they've been here for at least 2 years, then they're treated as an applicant for admission. That is to say, the border is internalized into their body. And even though they've been here, they may have children, whatever, they're treated as if they're still standing at the border. So that's a very profound constitutional issue. And as you might expect, we've seen a lot of problems already. This was from a report that's now 3 years old, and things have only gotten worse. From the American Immigration Council found that 43% of people surveyed had not been advised of a right to contact their consulate. More than half were not asked if they feared returning home. The law says they're supposed to ask that if you want to seek asylum, and so on. People signed documents that they didn't understand. Some people didn't receive proper documents, on and on and on. So what's the remedy for this? There has to be some process. There has to be somebody looking over the shoulder of the guardians. That leads us to this case. This was an asylum case. And as you heard, asylum seekers and refugees have special rights under international human rights law, but also under US immigration law. If a person has a well-founded fear of persecution on account of race, religion, nationality, membership of a particular social group or political opinion, they get special protections. We are not supposed to be deporting those people. Now, this is a complicated area, and I'm oversimplifying a little bit, but that's basically what this particular case was about that came to the court. Mr. Turasigiam was from Sri Lanka. He was apprehended soon after crossing the US border, according to the Supreme Court. Very simple. Justice Alito wrote an opinion, described him as, quote, a Tamil asylum seeker who had fled Sri Lanka and claimed that he had been abducted and tortured. I'm going to tell you a little more context about that in a minute. Anyway, an asylum officer, quote, after a brief interview, unquote, determined that he had not established a credible fear of persecution. A supervisor approved it, this is routine, and an immigration judge affirmed the finding in a quick checkbox decision. the basic point is he never had a hearing. Now, if you look at some of the proceedings below, you get a little more texture to this. He said that he had been approached by men on his farm who identified themselves as government intelligence officers, knew him by his name. He was pushed into a van. He was bound, beaten, interrogated. Political activities were inquired into. He then endured additional torture before he woke up in a hospital where he spent several days recovering, and he went into hiding and fled in 2016. That is a serious asylum claim by any measure. And the idea that this was not taken seriously is very worrisome. But here's what happened in the case. Justice Alito, writing for a 5-judge majority, and there were 2 concurs, one of whom, by the way, was Ruth Bader Ginsburg, which is a complicated question, but they did concur to some degree in the outcome, she and Steve Breyer, but there were basically 5 for this proposition, said that his habeas corpus, Suricigium's attempt to get a judge to take a look at what had happened here in this summary government proceeding could not be brought. Because he was a non-citizen seeking initial admission, the court said, he has no habeas rights or constitutional due process rights. This was rather gratuitous by the court, beyond what might be granted by the statute. In fact, one particular interesting point about this, and it's a tragic point, Alito actually discusses the case, the Somerset case of 1772, which was a very important moment in human rights history where a slave was freed by a judge in England because slavery was not recognized in the UK, and that freed slave had done it via habeas corpus. Alito distinguishes that case and says that's not really a precedent for human rights or anything, it's just that English law allowed him to reside in the country. It's an outrageous reading of a very important human rights precedent, and it's quite chilling. Anyway, Justice Sotomayor, joined by Justice Kagan, writes a very powerful dissent, saying that the court has now held that the Constitution's due process protections do not extend to non-citizens, and they may be cast to an unknown fate. She says this means there's no way to ensure the integrity of expedited removals, and it upends settled constitutional law, all of which is true. And in conclusion, and it's quite chilling, but this is where we are. The court, she writes, paves the way toward transforming already summary expedited removal proceedings into arbitrary administrative adjudications. What does this mean? It means that people will die, that people will summarily have their asylum claims denied. We're already seeing they're being shuttled off to Mexico, to the border. They're facing COVID, all kinds of things. And no judge may take a look at many of these kind of cases. As Justice Sotomayor said in a different context, where else do we allow a government agent without a neutral party looking at the decision to detain someone? She said, that's lawlessness. That's basically saying that we're not a country of law. We're a country of arbitrariness in detaining people and locking them up. And I'm very sorry to say that is where we are now. And with that, I will stop the screen sharing and hope that we can have some Q&A and meaningful discussion about how these 2 presentations relate to each other and other matters. Thank you very much.
Thank you very much, Dan and Amelia. That's a very sobering note to end on. And we have a first question that was submitted. I think it's a question for both of you, if I may. It says from Antonio Mata, how can we ensure that the UNHCR stipulations be applied to mothers crossing the border? From a human rights class that I recently took, something that I learned was that human rights law are applied very differently across the world. Not sure which of you might want to take it up, but I think it crosses both presentations.
Dan, I think you will provide a better legal response to that. What I found in the research is that human rights laws are countries subscribe to human rights laws, but the application and the implementation is not working due to gender ideologies, to nationalistic ideologies that prevent what is existing to to protect women and children. And also there are many gaps in the legislations, like scholar Ramji Nogales said once at a conference at BC in relation to the protections of human rights in transit. So then I will let that question to you from a legal perspective.
Well, I think this is the fundamental question, because if you don't have a way to get before a judge, and the writ of habeas corpus is the way that at least the Anglo-Saxon legal system, and in other variations now around the world, all legal systems have said there has to be this last gasp moment where a person who is arrested or detained or is about to be removed to face possible torture can say, something is really wrong in my case. If you don't have that, then it is really hard to understand how rights can possibly be enforced. I mean, we do have a project that was designed in an earlier era to contact people after they've been deported, to interview them and say, if this happened to you, maybe we can get you back into the legal system, even though you physically are now in Mexico or Honduras. And we have had some small successes with that. I mean, actually some big successes, but a very small number of cases. But essentially, human rights will not be meaningful if people cannot get before judges. And that's why I'm very worried about this decision. And that's why I thought it was important to talk about this case together with the research that you've been doing. I think the people who are migrating feel this already very acutely. But it's extremely worrisome if we get to a situation where the courts are saying, no, this is just up to the government. That's always a formula for oppression and harm.
So there's another complicated question. Amelia, first there's a question as to how many of the women were fleeing gender-based violence, and did they try to seek asylum on that basis? And a related question is, what kinds of proof do claimants need to be able to claim credible fear of persecution? So maybe we'll start with Amelia and then move to you, Dan.
Brinton, I didn't hear the first question.
How many of the mothers were claiming asylum based on gender-based violence?
Okay, so I have four women in the sample were claiming asylum based on gender-based violence. Yes. The way we did the research at De Novo, we protected the identity of women participants, so I didn't know how the attorneys took the cases of each of the women. We didn't know who we were talking about, so I don't know exactly how they claim their asylum, but I do know that in my interviews, 4 women said that they were running away from gender-based violence, from intimate partner violence, but also gang violence is gender related in many times. What I saw is that gang members, they threaten the women to take away their children, and that's how they obtain their money. So that is another way of gender-based violence directed to women who are mothers.
By the way, let me jump in on that, because there's a whole other problem, a whole line of cases we can't get into today, but the Trump administration has been working very strenuously, particularly Jeff Sessions early on, to eliminate the possibility of getting asylum based on gender-based claims, gang claims, intimate partner violence. All of that is under attack as well. But at least that is going to be going through the courts and is going to be challenged. So that'll take some time to work itself out. But that's another front where the human rights fight is taking place.
So Dan, do you have anything you can add to the question of what kind of evidence one needs to make these claims?
Well, it's difficult, but the case law as it's developed over time has said the courts have recognized that people can't be asked for very heavy proof of these kinds of things. People don't get letters from their dictators, as they used to say. So the person should be interviewed, but they should be interviewed in a sensitive, careful way by somebody who's a specialist in asylum human rights law, who's been trained properly, not a frontline Customs and Border Protection agent, but somebody who has been trained. And even then, there should be protections for them, particularly if it's somebody who's been traumatized or if it's an unaccompanied minor. So often the only thing the person reasonably can offer is their own testimony. And then you look and see, does the story hold together? Are they basically credible? Are there contradictions? This, of course, is why people who have the assistance of a lawyer can make a much better case, because they can be helped to think systematically about how can I tell this story, and maybe to gather something. A letter from somebody sometimes is possible, or you can have background research on country conditions through the State Department country reports, or international human rights law reports, or Amnesty International. So the cases are difficult to prove, but if you do it in an expedited removal setting, where you've just been arrested, you're incarcerated, you're intimidated, you're threatened, and then you know it's going to be a fast-track proceeding, the possibility of actually making the case or proving the case is drastically, drastically reduced. We know from good studies that even in regular immigration court, which is recorded and you have robed, they're called immigration judges. They're not federal judges in the same way. They work for the Department of Justice, but they are judges, administrative judges. Even there, the grant rate among people who have time to prepare their case and have a lawyer to help them prepare it is much, much, much higher. And that is not because these cases are fraudulent or anything. It's because they're presented in a way that is more convincing, and it just takes time and effort to do that. So the expedited removal setting makes it extremely difficult, especially for a person who might have a complicated case based on partner violence or gang membership. Those cases are always hard to bring anyway. By the way, that was not true of Mr. Turisidium. His case, if true, and there's no reason to think that he was not credible, is a classic asylum case. That's another, I mean, that would be one of the easier sort of cases to prove if I were his lawyer.
Well, that moves us from a micro or individual level question to a broader question. Two questions from Sonny Robinson. The first she describes as the obvious one is, what do we do in this context? How do we convince even the Democrats, if we can get them elected, to be courageous enough to address human rights violations like this, especially when the federal judgeships are increasingly conservative?
Well, let me say one thing about that. This is really different. I mean, I criticize the Obama administration strenuously. The deportation policies that took place during the Obama administration were horrible. But what is happening now is a completely different characteristic of enforcement. It is just brutal beyond any historical precedent. So this is one of those elections that really, really, really did have consequences in the enforcement system and will have consequences after that. Frankly, a lot of this could be solved without federal judges if you had an administration that was taking human rights even a little more seriously in terms of the enforcement. The family separation, the Remain in Mexico policy, the denial of refugee claims, the numbers being way down, the mandatory detention, all that stuff would not happen. So you wouldn't need habeas corpus if you had an administration that was even back to the norm, even back to the norms of the George W. Bush administration. I never thought I would hear myself say that, but they were much better. I just would say you cannot overstate how bad things have gotten in terms of enforcement in this country. But having said that, it is true that the federal judiciary has been packed to a certain degree with conservative justices, although not all of those justices are unable to see the issues that are presented here. I mean, even Neil Gorsuch wrote what was actually a rather protective majority opinion. So it's hard to predict sometimes where the courts will go on these things. But I do think that this election is life or death for many, many people. I'll turn it over to others to elaborate on that. Brenton, maybe you have some thoughts.
Well, just to add to the macro dimensions of this, it also happens to be today as the World Day of Migrants and Refugees, which calls to mind the importance of organizing and social movements in addition to the kinds of legal interventions that we're talking about today, and the importance of the law and the importance of challenging those laws. Not to in any way not support Dan's comment about the upcoming elections and the importance of these elections. It's complicated to get on the agenda of social movements these days because there are so many issues around which people are organizing, but making the connections between the demands of Black Lives Matter and the treatment of African Americans and in this country and Latinx and peoples of color, as well as migrants, is critical importantly, I think, for those of us in social movements. Amelia, I now have a question for you from Marissa Siegel, who describes your work as very inspiring and wants to know if there are women you interviewed or others who have been through so much danger and violence and made great personal sacrifices to get to the United States, question their decisions now that they are here, particularly living in the context of the pandemic. How has the pandemic influenced their lives now that their children cannot go to school? And is it perhaps harder for them to find work? Do you know if any of these mothers with whom you spoke are having more difficult and regret their decisions? You're muted, Amelia. Thank you.
Sorry, the study stopped before the pandemic started, but I did have connections with some of these women. One of them got the virus. They live in areas which are very much affected by the pandemic, like Chelsea or East Boston, and they got the virus. And they also they work in industries that are hardly affected, like restaurants or industries where they are all grouped together. So these are the people that are the most affected by the pandemic. I don't have any answer about the schools or what you're asking about the children, but that is a very good question if I do a follow-up study to see how the pandemic impacted them. I did another study with immigrant communities in Lawrence, and these families were really impacted more than others due to the nature of their jobs, their living conditions in small places. Yes, they were more affected.
Thank you, Amelia. And here's a follow-up question from Anna, who also interned at De Novo and reflects that the descriptions you gave are parallel to many of the experiences that she knew. She's wondering if you spoke with any of these women about the difference that legal representation has made, at least in the face of the difficulties that they face in the United States.
I didn't need to talk about this because the women knew that they needed to secure a lawyer. So they knew this, and the anxiety was that they couldn't find an immigration attorney because they couldn't afford an immigration attorney. And the ones that are working tirelessly, like now I think Jill and Lisa are here in the audience, they cannot take all the cases because they can just take some. So the women are aware of their need to prove their cases, but it's just the difficulties in accessing and legal representation.
Also, just to highlight, in expedited removal proceedings, many people just don't have time to get a lawyer. You know, these things can happen very, very quickly. They don't know who to call. They don't have the opportunity to call anybody. So, and now if you can't file a habeas corpus petition, then you may find yourself deported before you can even have a chance to find a lawyer.
Mm-hmm.
I just am noticing, I know we could talk about these issues for much longer, but we're running up against the time that we allocated for the presentation today. I'm wondering if we could give you, Amelia and Dan, one more minute to make any closing comments and then thank people for being with us. Do you want to add anything, Amelia, and then Dan?
I just want to add that I hope I could show the humanity behind these experiences and show that it's human beings and just affected by contexts that are so much difficult than the ones that I live in and raise my children. So if we can just see humanity and treat them as such, I would be happy.
Well, I just want to commend you on this work. I think it's fantastic work. It's very important to bring this dimension into what can sometimes be very technical, legal disputes, but this is the heart of what it is we're facing right now. And I guess my last word would just be vote, 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 vote.
And I would like to thank both of you because I think that this panel brings together the commitment of the Center for Human Rights and International Justice to look at these issues from an interdisciplinary perspective. That is to bring the humanity into our conversations, but to keep us attuned to the technical expertise that many people can bring to this. And then the challenges for those of us engaged in participation as citizens, as Dan suggests, to vote, and then participations as citizens who will take to the streets to demand that we embrace all human beings and embrace their rights to live among us and to secure a life of equity and justice for themselves and their children. Thank you both very much, and thanks to all of you who came today.
Thank you.